Same note, High Court Judge Grace Nzioka Wednesday sealed Joseph Jowie Irungu's fate by handing him the death sentence over the murder of businesswoman Monica Kimani in 2018. The ruling, giving new jurisprudence to the Francis Muruatetu and Wilson Mwangi appeal against the state over the death penalty. Moige William takes a dive into the Nzioka ruling that cited the 2017 Supreme Court ruling that declared mandatory death sentence unconstitutional, as provided for under Section 204 of the Penal Code, but not affecting the validity of the death sentence under Article 26 of the Constitution. Just what guided Justice Nzioka.
In the sentencing to death of Joseph Irungu at the Milimani Law Courts Wednesday by High Court Judge Grace Nzioka, the prosecution side cited the Francis Muruatetu case of 2015, where it stated that despite the decision in the case of Muruatetu, the death sentence is not unconstitutional. Nzioka saying that the matter, which was before the Supreme Court, only declared that the mandatory nature of death sentence is unconstitutional and not the sentence itself.
Sentence provided for the offense of murder, which sentence is stipulated under Section 204, which says that a person convicted of the offense of murder shall suffer death.
The ruling by Nzioka has been supported by Advocate Seth Ojenda, a senior law lecturer at Mount Kenya University School of Law.
But again, in the sentencing policy, Justice, the judge has really given an insight, very intelligent insight.
In the Muruatetu Mwangi case, which Justice Nzioka numerously cited during the sentencing of Irungu, 2 murder suspects had been handed the death sentence for the murder of business person Lawrence Gidenji Magondu, and they wanted mandatory death sentence as set out in the Section 204 of the Penal Code, removed by the Kenya law, arguing that it was unconstitutional. The two also wanted indeterminate life sentence be declared unconstitutional.
Despite the decision in the case of Muruatetu, the only thing that case did was to declare, and I will put it clearly, that the mandatory, and I will repeat, the mandatory nature of the death sentence is unconstitutional.
Irungu was granted 14 days to appeal the sentencing. The ruling further raises questions into the death sentence in the country, even as Section 204 of the Penal Code is seen by law experts to be inconsistent with Article 26(3) of the Constitution, which states that a person shall not be deprived of life intentionally, except to the extent authorized by this Constitution or other written law. The Supreme Court later guided the Office of the Attorney General on the interpretation.
And even the Muruatetu case itself, it was left that in the guidelines itself that yes, it is not outlawed per se, but now the court will be guided discretionarily by the policy while meting out sentences.
The Grace Nzioka ruling now gives a new shred of jurisprudence to the Supreme Court ruling to the Muruatetu appeal, despite the same court directing the Speakers of the National Assembly and the Senate, the Reforms Commission, the Attorney General, and the Kenya law to attend with a signal of utmost urgency for any necessary amendments, formulation, and enactment of statute law to give effect to their judgment on the mandatory nature of the death sentence and the parameters of what ought to constitute life imprisonment, but that is yet to happen. Moige William, TV4.